Hello everyone, welcome to Master Stage, and today we'll discuss land laws, okay, which is part of LL.B. Okay, it is very simple and easy. Do subscribe and share with your friends. Okay, so we'll discuss about the introduction to land laws. So what is land law? Land law, it governs ownership, use and transfer and acquisition of land. So every lawyer should know. So many disputes comes through lands. Okay, so what I'll cover here: land classification and ownership, land reforms and revenue system, acquisition and compensation, tenancy, and we'll check about the Telangana-specific acts. Okay, so let us have what is the different types of land or classification of lands. So one is agricultural land, government land, forest land, assigned land, Podambok land, ceiling. So what is agricultural land? So the land is used for farming, cultivation. Okay, it is common in India. Then it comes to government land, so which is owned by the very state government or central government. Okay, and which cannot be sold freely. Forest land, so which is protected under the forest acts. So most of the time tribals have the right over forest land. Then assigned land, so the land is given to the poor or scheduled caste, scheduled tribes by the government. So that particular land cannot be transferred, that is totally prohibited. Then Poramboke, so this is called as common land, so like roads, ponds, gazing for the sheep. Okay, it is no private ownership. So what is a ceiling? Okay, surplus land above the legal limit, okay, which is taken by the government for redistribution. So how you have to remember the classification of lands? Okay, AGF, A, P, C. Okay, A for agriculture, G for government, F for forest, S for A for assigned, P for Porambek, C for ceiling. So these are the classification of lands. Let us move to the next slide. So ownership of land. So we discussed classification of land. Now we'll discuss type of ownership of land. One is absolute ownership. So that means full rights to the use or sell or mortgage to that particular land. That is called as ownership of absolute. Then limited, that means there is a restriction. So some rights are there with specifications to conditions. Lease, that means temporary right to use property. Then tenancy, tenant cultivates and pays the rent. So these are the ownership of land: absolute, limited, lease and tenancy. So ownership ranges from absolute, that means full rights, to license, just have the permission. So each type has different legal protection. So what is absolute ownership? Owners can sell, have the right to sell, right to mortgage, right to gift. Whereas tenancy, so the land is given for the cultivate of the land, so the tenant pays the rent to the landlord. Mortgage, that means land is given as a security to get the loan, that is called mortgage loan. So many times they may ask difference between lease and license, etc. Okay, let us go to the next slide. Importance of important doctrines or important terminology. So here one is eminent dominion, escheat, Bona, Vacantia. So these are the new terms we have to remember. Eminent dominion means state can acquire any private land for the purpose. Okay, they'll give the compensation basis according to the article 300A. Okay, Then escheat, that means if a person dies who has no heirs, legal heirs, so that property goes to the state government. Okay, so example, intestate death without family. Then Bona Vacantia, so this is called as ownerless property vests in the state. Okay, similar to the escheat but apply to compensation too. So the case is, you have to read State of Bihar versus Kameshwar Singh. So it is an eminent dominion upheld with a fair compensation. So these are the things. Let us go to the next slide. Telangana rights in land. So what is the rights are there? So we'll discuss about the Dharani. The Telangana rights in land Pattadar Passbook Act 2020. So what is Pattadar Passbook? Pattadar Passbook is a proof of land. So the ownership issued to the farmers. What is title deed? So it is a legal document confirming the ownership right. Then Dharani Portal, it is an online platform for registration and mutuations. Then, so in order to prevent the fraudulent transfer, ensure the conclusive titles. So what you have to remember, Dharani is the digital land records plus Pattadar Passbook plus title deed in one system. This is the Telangana rights in land, that is the Telangana rights in land and Pattadar Passbook Act 2020. Remember this thing. Okay. Then what is land titling system? What is land titling? A system that gives conclusive or final proof of land ownership registered by the state. Then one is called Torrens System. So it is originated in Australia. So state guarantees title once registered. So the title is indisputtable. That means it cannot be challenged. So remember, Torrens equal to title guarantee equal to state backed ownership. So what is the advantages and disadvantages? So it reduces the land disputes, okay, and easy bank loans and land, transparent records. What is disadvantages? It's costly to implement, okay, old records had to digitize. This is the thing. Let us go to the next slide. Let us go to the next slide. We discussed about the land titling system. Okay, now we'll discuss land reforms in India. So it is categorized 4 types. So one is pre-independence, where Zamindars and British exploited farmers, no ownership rights for the cultivators or farmers. And the second step, between 1947 to 1960. So during this period, abolition of Zamindari system, then land laws got importance, then there is a tenancy protection begins. It is 1947 to 1960. And third one, 1970s to 1919. There is a ceiling surplus land redistributed for the scheduled tribe protection and strengthening. And 2000 to present now, the land records got digitalized, like Dharani Portal, LRR Act 2013 and Forest Rights 2006. So always remember about the objectives of land reforms. So why the land reforms taken place? In order to have the equity and productivity and social justice. That is the objective of land distribution or reforms. Okay, so let us have land revenue system. Okay, it is the land revenue system categorized. So there are 3 ways of land revenue system. One is Zamindari system, second one is Ryotwari system, third one is Mahalwari system. Okay, what is Zamindari system? So is a Zamindar, then a Zamindar here there is a middleman. Okay, so between the farmers and government. So this is called as Zamindari system. Then Ryotwari system. That means right means farmer. Okay, he deals with the government directly. Okay, so that is called Ryotwari system. What is Mahalwari system? So whole the village pays together to the government. So that is called as Mahalwari system. So right, what is Zamindar system? Landlord collect the revenue and farmers are tenants, and which is introduced by Cornwallis 1793. Then Ryotwari system. So farmers pays the revenue directly to the government. So which is introduced by Munro in Madras. Mahalwari system. So village community pays to collectively to the government, which is introduced in North India. This is the thing. So many times they may ask in the exam about the Ryotwari system, Zamindari system, Mahalwari system. So just remember, I hope you understand the same. Okay, then let's go to the next slide. So intermediaries and their abolition. Who are intermediaries? So intermediaries means they are the middleman who collect the rent from the farmers and paid to the British. So the intermediaries are Zamindars, Jagirdars, Inamdars. So these are called as middlemen. They collect the rent from the farmers, but they pay to less to the British government. So they are exploited farmers. So why abolished? Why these intermediaries, or why these Zamindars, Jagidars, Inamdars, why they are removed? Because they exploited cultivators or farmers. So there is no direct link between farmers and the government. So it is abolished because directive principles. So article 39B and C. So this is the thing. So the best case for this intermediaries and their abolition, State of Bihar versus Kameshwar Singh 1952. So it is the first major challenge to Zamindari abolition. Okay, Parliament added ninth schedule to protect these laws. So how it is happened? They identify the intermediaries and they pass the Abolition Act. Then Westland that will be redistributed to the poor people. Okay, that is the thing. Let us go to the next slide. Tenancy laws. So what is tenancy law says that tenancy means tenant cultivate the land owned by the landlord and pays the rent. So the farmer cultivate the land and pays the rent to the landlord. That is called tenancy. Then protected tenant. That means the farmer, the tenant with the continuous cultivation for the fixed period gets the protection from the eviction. So that means protected tenant means the farmer, they have the specific period they can cultivate continuously. In between the tenant, that the farmer cannot be removed. That is a protected tenant. Then ownership rights. Okay, so protected tenants can claim ownership of land they cultivate under the Reforms Act. So people are cultivated the land for many days or many years, and the ownership is given to that particular person who cultivated. That is there under ownership rights. Then termination. Termination means removal. So tenancy ends only on valid grounds. So the cultivator, the farmers cannot be removed from the land, only with the proper reasons only they can terminate it. So if the farmer or cultivated don't pay the rent or personal cultivation by the owner, in that particular situation only, that can be removed. So what you have to remember, land to the tiller. So core principle of tenancy reforms. So instead of having the land with the landlord, it goes to the tiller. Okay, దున్నేవాడిదే భూమి. That is the main concept. So let us go to the next slide. So Land Acquisition Act 2013. So many times it is asked in the examination. Do remember. So the full name, Land Acquisition Act full name is the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. Simply we say that LARR Act. What is that? The Rights to Fair Compensation for Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. Why the new act is required? So old act 1894 had no content, no SIA, poor compensation. So that is the reason new act come into picture. So what is the public purpose of this Land Acquisition 2013? So acquisition only for the roads, schools, defense and infrastructure. So Land Acquisition Acts, why it is need in order to government needs the land for the construction of the roads, schools and for the security of the purpose infrastructure. Then social impact. So it is mandated to study how the acquisition affects the community. If the land is taken or acquired by the government, the people of the owners of the land will get the affected by building the dams, roads, schools, defense system. So what is the social impact that you should know? Fair compensation. So those who are lose their money, there is a 2x to 4x market price valued for the land ownership. So if the land value is 2x, that means double will be given for the rural. If it is urban area, it is fourfolds that will be given. So the key changes in 1894 Act. So no consent needed. So according to 2013 Act, 80% of the consent required to for private projects. Okay, this is the Land Acquisition Act 2013. This is also called as the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. This is called as LARR Act. Okay, let us go to the next slide. So how the land can be acquired or acquisition? First they have to give in the notice. So and so this much land is going to be acquired for the different purpose, for the infrastructure purpose, for the school purpose, and they will assess what is the impact. People lose the land, they lose their work, okay, livelihood. So they will assess, and for example 100 people are there, in which even if the 80% people are agreed, then so declaration of the award. So this is the land is going to be taken, then they will give the compensation or payment. So the process requires transparency, fair treatment to the landowners. So any aggrieved person can approach land acquisition collector and then the civil court. If somebody lose the land, are going to lose the land, first point of contact they have to contact their land acquisition collector. Okay, then if it not satisfied, then he will go for the civil court. So many times it is asked in the examination, explain the procedure of land acquisition under LARR Act 2013. Let us go to the next slide. Compensation and rehabilitation resettlement. So the compensation, okay, people are lose the land, for them we have to give the amounts, okay, market value. The compensation will be 2x market value in urban area, 4x market value in rural area. So rehabilitation. So if the people lose the land, they need to get the housing, employment or annuity. So rehabilitation R&R packages is compulsory. So dispute resolution. So dispute to the land acquisition collector. If you have the dispute, if you are facing that, if you are not getting the proper amount for your land, you can go to the land acquisition collector. If not satisfied, go to civil court. Still not satisfied, go to high court. This is the thing. Okay, so remember, solidity means 100% extra on market value. Okay, then the total is 2x or 4x solidity. So what is the market value is there? 100% will be given. Then if it is in urban area, the market value will double in. Okay, if it is in rural area, it is 4x market value. That amount should be given. So ceiling on agriculture land holding. So as per the Telangana land reforms, there is a ceiling on agriculture holding Act 1973. What is ceiling? So maximum land one person or family can hold. So this much amount of land one can hold. Above that will be given to the government. So surplus land taken by the government and given to the landless poor. So people have the X amount of land. Okay, if it is crosses that, okay, particular ceiling, particular limit, the extra land will be given to the poor people. Then ceiling limit varies by land type, and like if the ceiling will be whether it is irrigated land or dry land. So this Telangana land reforms or Telangana on Agricultural Holdings Act 1973, the exception given for the temples, education institutions and cooperative farms. So why this ceiling on agriculture holding? So in order to prevent the monopoly, okay, on the land, and also ensure that equitable distribution. So article 39b, so material resource for the common good. This is the ceiling on agriculture hold. Okay, let us go to the next slide. So constitutional provision for land. Okay, there are four things we'll discuss. Article 38 says that state shall promote welfare and reduce the inequality in income and ownership. Okay, what this article says that the government shall promote welfare and reduce the inequalities in income and ownership. That is said in article 38. Then article 39b and c, so material resource of community to be distributed for the common good. No concentration of wealth. So wealth cannot be concentrated on only one person. It need to be distributed. That is the article 39b and c. Then article 300a. So it says that no person shall be deprived property except authority of the law. Okay. Then article 9. So schedule 9 what it says, Land Reforms Act placed here cannot be challenged in court or fundamental rights ground. Okay, land reforms are made, so which you cannot challenge. Why you are distributing the land to the poor people? That cannot be done as per the schedule 9th in the Indian constituency. So the key cases here: constitutional provision for land, Keshavananda Bharati versus State of Kerala, 1973. So it is a basic structured doctrine. Parliament cannot destroy the core rights even via 9th schedule. So remember, Keshavananda Bharati versus State of Kerala. Okay, this is the constitutional provision for land. Okay, then Forest Acts. Okay, so here you can see the tribal people. Okay, scheduled tribes and forest dwellers. So scheduled tribes only are the people who resides in the forest. So the scheduled tribes and other traditional forest dwellers. So it is a recognition of Forest Rights Act 2006. So it recognizes the rights of tribals who live in forest for generation. So these people are stays in the forest for the many years. They cannot be eliminated. So some rights are given. Not some rights, 100% rights are given. So rights are individual rights. So they can cultivate forest land. Then community rights, as a they can use of forest produce, fruits, gums, etc. Habitat rights, so they can protect their traditional area. So in order to acquire forest land, the Gram Sabha need to approve the claims. Then state government issues the title. It cannot be evicted without Gram Sabha consent. Okay, so these Forest Rights Act 2006. Okay, let us go to the next slide. Okay, assigned lands in scheduled areas. Okay, what is assigned lands? Telangana Assigned Lands Provision of Transfer Act 1970 says 1977. So government assigned land to the poor people, SC/ST. So this transfer totally prohibited. Okay, the government can resume if misused. So assigned land means excess land given to the poor people, SC/ST. Okay, this land is assigned lands. Okay, if it is that lands is misused, the land can be taken back by the government. That is the Telangana Assigned Lands Provision of Transfer Act 1977. Then Scheduled Areas Land and Transfer Regulation. So the scheduled area. So that means protected tribal land in scheduled areas. So non-tribals cannot purchase the tribal land. So for this, special tribunal resolves disputes, illegal transfers are avoided. Okay, so the scheduled areas land which cannot be transferred to the non-scheduled people or non-tribal people. So dispute resolution. So assign land for the scheduled area. If the some dispute comes, there is a special courts and tribunal, so which handle the land disputes in tribal and scheduled areas. So faster resolution than civil courts. So we already know the special courts and tribunal in order to solve the problems immediately. Okay, so what you have to remember, assigned land means the land is given by the government which cannot sell or gift or mortgage. So if the violation of this assigned land happen, the government can taken back. Okay, remember these terms so that you can perform in the exam very well. Then let us go to the important cases at a case laws at a glance. So when you're writing the exam, try to write these things. State of Bihar versus Kameshwar Singh, 1952. It is the first Zamindari abolition challenge, so which led to first constitutional amendment, that is 9th schedule. Then Keshavananda Bharati versus State of Kerala, 1973. So basic structure doctrine, that means parliament cannot destroy the fundamental rights even for the land reforms. Then Indira Sawhney versus Union of India, 1992. So confirm reservation for backward classes. So reserve to land distribution for SC/ST. Then Samatha versus State of AP, 1977. Supreme Court held for tribal land in scheduled area cannot be leased to the non-tribal or companies. So quote these important cases in your answer sheet. Then the evaluator will get the interest and he will give the good marks. So what we have remember, LARR 2013. So we discussed about the Forest Right 2006 and Assigned Lands 1977, Sealing Act 1973, then Dharani 2020. Okay, that if you want you can take the screenshot of this one. Then key articles, Article 38, Article 39B and C, then Article 300A, 9th schedule. So key cases here, Kameshwar Singh versus plus Keshavananda Bharati and Samatha versus AP, that you have to remember. So first understand the concept, remember the keywords, write the legal terms, so you will score the high marks. I hope you enjoy this class. If you are really like this content, do share with other students so that they will benefit it. Signing off, your Mohan. Thank you. All the best for your coming examination.